I mean, I believe in the DA being able to do it through diversionary, which we really believed in. We see the hiring of a Vera Institute, which was national best practices. But every time I hear you all talk about it, I get this feeling that maybe, and when Vera first came aboard, there was this concept that when their grants ran out, we would phase that into a public agency where it would be more appropriate.
I only speak for me. I don't speak for our court, and I'm not dancing around the issue. We've discussed it in our court. We've discussed, would we as a court want to take over pretrial services?
Would you?
What would it look like?
Am I addressing the elephant in the room? Is that a mistake? I mean, we not discuss it?
Personally.
Okay.
I need to have as much information as possible so I can make, hopefully, the right decision. You know, there's a codal provision that talks about the different factors and elements that we need to look at when making a bonding decision. And one of the elements is the weight of the evidence against the accused. And I just don't have as much information as needed until Mr. Cannizzaro gets his police report and starts assessing the reliability and the credibility of the witnesses and making a call on whether or not he.
So where does pretrial play into this? I mean,
well, they don't play into the weight of the evidence component, and that is one of the components that means the most to me as a judge. I don't know how effective it is on day one on those tough charges. Certainly Vera and everyone else is effective if it's 2 marijuana cigarettes, a theft from the Walmart, a bad check to the Rite Aid. I think we all agree with that. What we're concerned about, at least what I'm personally concerned about, and I think I talk for the bench, and I think I might even speak for the DA, is those violent offenses. And again, we need more information, because the more information we have, the more intelligent decision we can make relative to the bond.
Yes, I think if I'm reading the counsel correctly, the counsel's looking to the court, the administration's looking to the court to say, we want pretrial services.
exactly.
We don't necessarily care who runs it.
Exactly.
But we want to make sure that whoever gets the money is doing the job.
I think the judges should absolutely make sure that the information given to you is helpful, is accurate, is exactly what you need to do your job. And if it's not, then obviously the provider has got some serious problems. So I don't know where the pretrial services dollars exactly should go, but I'm glad that we are all at least philosophically on the same page, that that service is one that allows you, if the service is done well, to do your jobs better and to make it more informed decision, because at the end of the day, you have to decide. Your paper can say it's a 2, and if you just know this person needs to be locked up in jail, you got to do it.
And Vera Institute said that they were fine with this going into the record. So, you know, if you guys don't, otherwise wouldn't have it, I would say let's just get it in the record. And if you all are in agreement, we'll talk to the pretrial services folks about that and say, you know, let's get that started. All right, and then I wanted to go to the Mother's Day shootings. A lot of it has been made about that, but it is true that the man had only had one conviction for one misdemeanor prior to that arrest that was made in March of this year. But it's also correct that the commissioner set a $35,000 bond. So obviously did not listen to the risk assessment, and that the defendant remained in jail for 7 weeks after he got that $35,000 bond set, and it wasn't until that bond was reduced that he was able to get out of jail on bond. So he was bonded out, and that's how he got out of jail.
Sometimes when we use the term pretrial services, we use it loosely, talking about stuff that happens pretrial, and sometimes we talk about it as if it's a particular entity. We have to make a decision on budget. We have to make a decision on where we spend a fairly sizable amount of money. And my question is, does the criminal justice system work better if we spend it on the group that we are currently using to evaluate inmates prior to trial, or is there a better way to spend that money? And in particular, I'm talking about the money we spent on Vera, or we are being asked to spend on them.
And when Vera came in, quite frankly, when they first came in, it was designed to be a handoff program to whoever it was going to be turned over to, that Vera was here to set up a prototype, help us with the setup, and then it was going to become another issue.
I assume that any pretrial services are there to aid you in what you do, and I need to know what you want us to do on that issue.
Kentucky has it set up. They've got the premier, so they say, the premier pretrial services. It's run by the judiciary because the judiciary sets up the protocol and the parameters. They set up the guidelines for who they're hiring because that's the person who's given the judge the information. That's the person that the judge is looking to. Traditionally, it's always been just looking to the DA. The DA is supposed to give us the criminal history and the bad stuff about the person. The public defender is supposed to give us the mitigating and the good stuff about the person. And then we make the call as the judge. Whether it's a good call or a bad call, we make the call. You've now inserted pretrial services, and the issue that you're asking is what do the judges want to see from pretrial services? There obviously been some issues with, I'll bring up the Mother's Day shooting. That was a case that obviously that person was given a risk assessment by pretrial services, and that person was given a bond that maybe was based on bad information that that arrested subject gave to the pretrial services person. We've got no control over who is giving us the information with pretrial services.
At the end of the day, members of the council, it is the judge and no one else who has to make a decision as to whether or not his or her name will be attached to that release. No one else's name will be made a part of a news story. No one else's name will be dragged through the gutter. When it came to the Mother's Day shooting, the judge was relying upon information from a third-party organization, who may not have had any say-so, but for the fact that they've been funded by the City Council or other government agencies. I can tell you this, I do not need a third party giving me information that when I was an assistant prosecutor under Mr. Connick, it was my job as the assistant district attorney to inform Judge Hanson and all of the commissioners in evening court the information regarding, I guess, risk assessment of an individual and the appropriate amount of a bond. It was the job of the prosecutor, and at the same time, the public defender would also weigh in on it so that the judge would be given as much information as possible.
I was just looking for guidance on what you, the judges, thought we needed to do with money that may be available to improve the criminal justice system.
I think we're all in agreement that if somebody gets busted for a couple of marijuana cigarettes or a couple of rocks or a bad check or stealing from the Walmart, those people don't belong in jail. It's when Vera makes a recommendation to the commissioner relies on it, the case gets allotted to Section L. The first couple of questions I'm going to ask is, what do you know about the facts of the case at this point, State? Do you have a full police report yet? What is his or her bill status? I don't have Vera in there at that particular moment in time. That's the pragmaticism of this. Vera is at one level, not necessarily at the next level. The buck's got to stop with us, as we've all stated, and we're here to review a bond and to review everything about a case every time a case is set on our docket. I know the first thing I do when a case is allotted to my section of court for arraignment, I want to know what the bond is. Again, I believe that we all recognize the overcrowding problems, and I think whether the legislature thinks that somebody on the third offense marijuana who's a double bill should be eligible for 20 years in the penitentiary, whether they think that or not, we all know here, or at least hopefully we all know here, that it's really kind of ridiculous. I mean, those are the easy ones. It's those other second-class cases where people are committing the violent offenses that we need to have actually more information.
Let me just tell you, Vera did tell us that they looked at 580 inmates, and they thought that over 250 of them should have been released, inmates who had not been released. At the current cost of about $30 a day, that's about $7,000 $7,500 a day to the city.
It's 40% of the population, if in fact those numbers are correct. That's outrageous.
And if the people are anywhere near right about what it's going to cost us after this consent decree, the numbers really get crazy on the daily cost of that. And I'm just saying it's a problem we need to figure out a way to solve. Thank you.
I've been sitting here patiently all day.
No, it's because you didn't have your name up till just now. Sorry.
Well, because I finally have a question. I've been listening all day, back and forth, to the rhetoric back and forth about the Vera Institute. And it seems to me that the judges are walking on eggshells. And I just want to ask you point blank. This is your one shot.
Here we go.
Zivelich, get your head up. What do you really think? Because I know what you say off camera. I want to get you to say it on camera. This is a $600,000 item that we're looking at in the budget. I'm looking at, Mr. Moret, how much did you say you guys are in the hole?
Approximately 863,000.
So that could almost wipe you out the hole. You know, you'd only have to find $200,000. Now, I'm not saying throw out pretrial services before everybody over here gets, you know, that she wants to throw away pretrial services. What I want to find out is, can we as a city operate pretrial services without Vera? And what I've heard from the municipal judges and what I've heard from you is that we could. And I would imagine if I asked the DA that question, he's sitting there, I don't think he wants to answer it. Because, you know, $600,000 is a lot of money. And I don't say that the service they provide is not a much-needed service, but I think that what we need to find out is, do we have to fund it to the full extent of the grant? Because we know when we write grants, we put things in that maybe after we get in operation, we don't actually have to have. So I really, and you know, each of you can make a comment, one of you can make a comment, but if none of you make a comment, then I don't want to ever hear about it again.
Start with what I think I've always said. I'm kind of a traditionalist. I'm kind of conservative in a lot of things. I began as an assistant DA in 1986. Our job as prosecutors was to march into first appearances. Ben was there. What? 10 a.m., 5 a.m., 5 p.m., and 11 p.m. 3 appearances. You'd march in there with your full rap sheet, your gist, maybe a little bit of about what happened to the victim. Your job was to advocate a certain amount of bond, right? Defendant's there, his lawyer, public defender's there. Their job is to advocate for mitigation, to say, Judge, he doesn't have a criminal history. They may have booked it aggravated battery, but it was really just a punch, right? The judge, hopefully the objective judge, makes a call. That's the way it's always worked. Pretrial services does do a good job in that they come in and they do a little bit more of a one-on-one with the defendant. But I'm going to go back to what I said 2.5, 3 years ago when John Wool, we were sitting in the basement at NOPD headquarters. I said, well, who's going to be giving the judge this information? Well, we're going to, you know, develop a criteria for hire. I'm like, well, what's going to be their background? Are they going to have a criminal justice background? How do they know how to read a rap sheet? When I look to the DA, they're an officer of the court. When I look to the public defender, they're an officer of the court. I love my daughter. I think she's brilliant. She graduated from Tulane with 2 degrees, but I wouldn't want her reading a rap sheet and talking to somebody, and that person who's arrested says, yeah, I'm in college. I live at home with my mom. I've had the same house for 20 years. I want somebody that is in there that has a vested interest in being an officer of the court to tell me as the judge what I'm getting ready to sign off on. I think that's the lack of buy-in that our court has with Vera and pretrial. I mean, I talked to a commissioner just last week, and they said, Judge, you know they don't go beyond 10 years. 10 years is their cutoff for the rap sheet. And I said, well, who came up with that mark, 10 years? What if the guy's got a murder from 15 years ago? Does anybody jump up and say, Mr. DA, does the DA jump up and say, well, you should go back beyond 10 years, Judge, because he had a murder in 1984? Those are the things we don't know as judges about Vera. We've got no control over who they hire, what they tell us, and what their mission is. Judge Wheeler, do you want to add anything?
Madam Council Lady, as I mentioned earlier, I believe the word utilized from the dais was best practices. And if I'm not mistaken, it was mentioned that in terms of best practices, the program which serves as the model here in the United States, is the state of Kentucky. And if we're being told about best practices, let's put it on the table. In Kentucky, Judge Burris told you that the program is ran directly by the judiciary. As I mentioned earlier, it is good to get as much information as possible. We require the information to come from the prosecutor. When I was a prosecutor, that's who had to do it. And many times the public defender would then weigh on it to mitigate whatever the bond might be. Now we've got this third party at the table, and again, I believe in what Ms. Guidry said. I would like to get the reports. I don't get the reports, so I don't know what benefit Vera has, or whomever the third party is, states in terms of whatever the bond might be appropriate. I don't know. I don't get the reports. So, as you would say earlier, if you're asking us, I'm telling you, according to what the council members mentioned earlier, best practices would dictate the best program, which is run in the state of Kentucky, says that it's run by the judiciary. If you want to save money, then let's eliminate some bureaucracy. If you want to save our citizens money, because at the end of the day, as I mentioned earlier, the decision comes from the bench. And it may put more emphasis on the defense attorney or the prosecution, who may look for an increase in the bond. It may put more an impetus on their jobs if, in fact, they didn't have this third party involved in the equation.
Here's the bottom line. Best practices does not ensure continuity. It's that simple. If there were a number, whether it was whatever the number is, 12, 15, 17, and that equaled $25,000, then you'd have all the continuity in the world. But at the end of the day, regardless of what the best practices are relative to the studies regarding Vera and everybody else, it does not ensure continuity amongst the 12 elected judges or the 13 elected judges. So the real bottom line is, how much extra utility are the citizens, the administration, and the court getting out of whatever additional information Vera provides? Again, what I've said before is, my concern is that at the first appearance, XYZ information is available. I'm looking for more information, especially if it's an aggravated burglary, a rape, a murder, an armed robbery. And I think that's the bottom line. You were looking for 3 yeses or 3 nos? You got nothing.
No, I got absolute, no, what you're saying is what I've heard privately. And I'm not really, I wanted you just to put your opinion on record. I'm not saying a yes or a no, because what I'm saying to you is that I've heard, when we've had private conversations, all the concerns. I've been sitting here for over 3 hours, 2 hours and a half, and what I hear is people talking from the dais about how great it is, and you guys responding back, but I don't feel comfortable, and I really have been listening. I don't feel comfortable, and in the end, I'm the person that's held accountable on the decision about bond. Because when a person's let out, if it's on just what I get from pretrial, and that person goes out and commits a heinous crime, then the media is coming to me. They're not going anywhere else. So what we have to weigh here is $600,000, and if you're apprehensive about what weight you're going to give to the services they're providing, then is that the best way to spend $600,000? So I just wanted your honest opinion. Thank you very much.
Your diversionary program works beautifully. I see that as a form of pretrial. Am I correct?
Yes, it is. It
All
is.
right.
It
And
is.
would it benefit us to put more there than we're doing now? And if so, it would mean funding you more than some of the pretrial that we're funding that runs too slowly? I mean, I don't know, because I don't understand the whole process as well as those of you in the system do. But where can we make pretrial be more effective to less time in jail, so the jail numbers will go down, the cost of the jail will go down, in your opinion?
Well, I certainly advocate in my address to you this afternoon that we would love to increase the number of people in the diversion program.
Okay.
I think the diversion program is a win-win for the individual.
Absolutely, and it's working better than anything.
And what we have said is we have almost we have quadrupled the size of the diversion program from when we took office. The program when we took office, there were maybe 200 to 250 people in the diversion program. Right now, we have about 800 people in that program. Certainly, if we had the funding to increase the number of counselors, I would love to put the diversion program in an area where we could have 1,500 to 2,000 people
What would
in
that cost?
program. I think I would probably need about 5 more diversion counselors. The counselors are making, and I know Val's going to, I think it's about $30,000 to $35,000 a counselor. I would need at least 5 more diversion counselors at about $35,000, which is what we pay the counselors. And again, I think the benefit is that we avoid someone even going through the process.
Right.
They do not have to, those 800 or so cases do not have to go to criminal court. They come into our office. They do not have to meet with the Department of Corrections.
And they don't get
probation
that, they don't
officer.
get that dark mark against them, as you pointed out, and they don't take up jail space and time and processing, which costs money,
That is correct.
and they don't take up criminal court time. I mean, it seems like the biggest win-win we have going in this whole system. So 200,000 would do it, Val?
It's when you
200,000?
when you factor in fringe benefits and that sort of thing, it's about $50,000 a position
So 250?
for 5 positions. Yeah.
250,000? That seems like a bargain. Okay, I'm going to save the rest of my time for someone else that might need it. Thank you. You answered my question.
Good afternoon, DA. You've answered everything that I had written down to ask, but are you saying that you believe that money should be taken from the pretrial services program to be put to your diversionary program?
You know, council member, if you asked me that, would I take the money if you offered it to me? In a heartbeat, I would say, yes, ma'am, I would. I believe that I can do. Look, I'm going to brag about diversion because I'm very proud of it. I believe we can do the job. I believe if you give us an individual who gets arrested on the street for a nonviolent offense, a first or second offender, if you give me the money, I honestly believe I can do more with that individual in the year to 2 years that I would have him under my supervision. And I'm not trying to knock anybody else's program, but I'm very proud of what we do. And I believe we have done it very well, and I think we can continue to do that. And as I said, in response to Ms. Clarkson's question, if I have about 800 people in the program right now, give me 5 more counselors, and I'd like to increase my program, I can almost double the number of people that I have in the program.
And DA, aren't those all people who have admitted guilt?
Yes, ma'am, that is correct. That is, in other words, we do not accept someone in the program unless we believe we have a prosecutable case against them. If we believe the search is bad or the evidence doesn't prove that they are responsible, then the charge would be refused. We do not place them in the program. That charge would in fact be refused.
Okay, so that's a subset of the people who may be served through the pretrial services program.
That is a subset of everyone who is arrested. Yes, ma'am. We do not take every person who is arrested and put them in the diversion program because there are going to be crimes of violence, there are going to be some multiple offenders, and there are going to be some charges where the cases will ultimately be dismissed. But yes, ma'am, it is, to answer your question, that is a subset of the entire population, the universe of people who are in fact arrested.
Thank you.
Okay.
Am I up?